start talking more about the why we've gathered you all here and what is the purpose of our 2 days here in Belgrade, I would like to give the floor. We have the privilege to have with us the Dean of the Faculty of Law of the University of Belgrade, Professor Zoran Mirković. This conference has been organized under the support and the auspices of the University of Belgrade Faculty of Law, of course, of the University of Lausanne, University Carlos III from Madrid, but our host is the University of Belgrade and the Faculty of Law. The only reason why we're not at the Faculty of Law is because the school year has started, so we have no premises. The students are in, so that is why we're at a hotel, but that's not too bad. So I would ask Professor Mirković to join us at the podium and give us a few words. Thank you, Professor.
Distinguished colleagues, dear guests, ladies and gentlemen. As the Dean of Faculty of the University of Belgrade Faculty of Law, I have a great privilege to welcome you today at this conference. My field is far away from this topic, but it's very interesting. Tax challenges in modern time, and I have no time to be all time at conference, but I would like to express my gratitude to all of you who came to contribute to this event, share your knowledge, and take part in the discussions. It is a rare opportunity to see so many competent and renowned professionals and scholars gathered at the same place. I hope that you will enjoy your time in Belgrade. I wish you an excellent conference. I thank all people involved in organization of this conference. It is very important for us as faculty, as academic society, and so. And I thank especially Professor Kostić. Thank you very much for your attention.
Thank you, Professor Mirković, for doing us the honor of opening this conference. I have the task as the local organizer to give a few introductory words before we actually start the working part of the conference. Now, what I want to talk to you about is actually the how we came here, what is our platform, and what do we want to accomplish with it, why Belgrade, and what's ahead. And essentially, the idea behind our platform, our International Tax Law Research and Policy Network, was developed between the four of us as an idea to have a space where I have to emphasize this relatively younger academics can cooperate between each other, can exchange ideas, can develop projects and implement them. And it was easy between the four of us to agree to this. Uh, I think all of you know it's Vikram Chand from the University of Lausanne, Andrés Báez Moreno from the University of Carlos III in Madrid, and Dr. Mario Tenore. Mario is a practitioner with a very, very strong academic background. So you might know him both from practice, but also from academia. And the idea was, well, if we are going to develop this, the best test is to have a project, and thus we're here. So we were thinking of what should this project be. And since 2013, since the BEPS action plan started and we have started developing these new ideas in the area of international taxation, what we really notice is a fundamental lack of focus on individuals. It's been mostly about corporates. And somehow it seemed that we have forgotten that it's not only capital that is mobile, humans are mobile. We have become more and more mobile as time goes by. Furthermore, if you look at it, digitalization has impacted our everyday lives, the way in which we do work. The place of work has disappeared. It is our laptop. and we can go in a park and work, and the tax profession is an example of it. We no longer need offices. It's actually a privilege if you have one, or a burden, depending on how you see it. So we decided that this is something that we want to focus on. And then we have picked basically and chosen people that we respect, value, and wanted to hear from. And this is how we've chosen the people that you will be listening to for the next 2 days. People that we are certain have something important to say in many of the aspects of this broad topic. We have invited as chairs and panelists senior academics, value practitioners, people from policy that we really think can contribute and provide value and guidance and input to this debate. Because in addition to the conference, the key value of this project is actually a book that will come out. So what you will be hearing today will become a part of a book that will be published, we hope, next year. We will press for publication to be as fast as possible. And it will be a book with 20 chapters dealing with the topics that you will be discussing for the next 2 days here. We have 22 authors. They come from various continents. So it is from the US, from America, from Europe, um, from Asia, South America. So we've tried to, I think we're missing Australia and Africa, but next time we'll do better. Now, if we are successful in this project, then we open up this platform for exchange and for participation of our peers. And we think that we can, through this exchange of ideas, do great things. Now, one of the reasons why it is good to have such an event here in Belgrade is that, and probably not many of you know this, but actually this is one of the places which gave significant results in this interaction of mobility and the exchange of ideas and new technology. It's not actually here, it's in the suburbs of Belgrade. It's a place called Vinča. It's a small village in the suburbs of Belgrade, which is one of the key points which during the Neolithic transition, the hunter-gatherers of Europe met with the Anatolian settlers who brought agriculture to Europe, and thus our way of life that we live today. So through this mobility and exchange of ideas, it's good things can happen. Now, bad things can happen as well, and Belgrade is also one of the examples. Some of you have heard this. I will say it to the broader audience. Because this is my city, and with this I will end. You have come either to the ugliest city on the most beautiful location in Europe, or to the most beautiful city on the worst possible location in Europe. You are on Via Militaris. This is the road from Central Europe to Istanbul. And everybody who has ever tried to go down there went through this city, and in the process had the idea of leveling city to the ground, roughly 44 times in the last 2,000 years. So on average, at every 50 years, the city has been leveled from Attila the Hun until the modern days, because it is a pass-through. It is a place through which you need to go if you are heading down east. So, but again, mobility and the exchange of ideas can have various sides. We'll discuss them all. Welcome. I would like to thank our sponsors. Without their generosity, this event would not have been possible. I would like to thank the Serbian Fiscal Society. And I would like to particularly thank two people. Behind the grandiose words conference secretariat, in addition to me, there are two ladies, Lidia Živković and Jasmina Miletić, and without them, this would not have been done. Everything that is good is thanks to them. Everything that is bad is sadly due to me. So forgive. But welcome, and I would like to ask the first panel to come to the dais, and we will now start off with the conference. Thank you. So I will serve as a conferencier of this session. So I would like to invite Sara Perret from the OECD, head of the Personal and Property Tax Unit, to talk with us about the relevant of this topic, the topic of the conference for the policy debate in developed countries. Please.
A little high. Um, Good morning, everyone, and thank you very much for this invitation to discuss this very important topic today of the international tax challenges raised by the mobility of individuals and workers in a context of increasing digitalization. This is highly topical, and I think it was mentioned already, but this is also of great interest to us at the OECD. As you'll see, because this is the first presentation, it's really intended to be more of a scene-setting presentation, a bit of an overview presentation, highlighting some of the key challenges that we will likely be facing in the future in this area. So if I can figure this out, yep. So maybe before getting into how relevant the topic of cross-border mobility is in today's world, it's probably not a bad idea to remind ourselves that it's actually not a new phenomenon. We know that globalization and international economic integration have led to higher capital and labor mobility. But it is true that the focus has very much been on capital mobility and the tax implications of capital mobility, with, on the other hand, the idea that labor is a relatively immobile tax base. So that was the traditional idea, with some exceptions, however, and some more mobile groups of the population. So typically high net worth individuals, highly skilled workers, but also potentially retirees. And so if we look actually at preferential tax regimes that seek to attract individuals, they've traditionally targeted these more mobile groups of the population. There is also evidence of tax-induced individual cross-border mobility. I've done a lot of work on wealth taxes, and that's definitely an area where there is anecdotal evidence of tax-induced mobility, so people leaving the country to minimize their exposure to wealth taxes. But there's also more solid empirical evidence of cross-border mobility in response to taxation, in particular personal income taxation. And there are a range of studies. I just cited one here, but they usually also focus on specific categories of individuals, whether it's top earners. There's studies on football players, studies on innovators. So, but that confirmed that there is a mobility response to taxation. So that was pre sort of, in the last few decades. Now, what is different today is that digitalization and remote work are enabling more and also different types of mobility. We've seen digitalization lead to significant changes in labor markets with the rise of teleworking, but also the emergence of new types of jobs, often via platforms. And I guess in today's discussion, because we're talking about cross-border mobility, influencers might be the most interesting category of these different types of platform jobs. So changes with teleworking and new types of jobs, which more generally means that there are broader segments of the population that have now become more mobile. The pandemic was definitely I don't know if it's a game changer, or at least a very big turning point in terms of the adoption of remote work, including cross-border remote work, sometimes chosen, sometimes forced. But anyway, it led to obviously a number of difficulties and challenges, which the OECD tried to respond to with its updated guidance on tax treaty issues arising from cross-border remote work that was released in January 2021. So that's the pandemic world. Post-pandemic, we don't anticipate that remote work will cease, including cross-border remote work. If anything, we think it will persist. It could also expand. The numbers that you see on this slide are expectations about increasing teleworking, not specifically cross-border teleworking, but nonetheless, there is this expectation that this is a practice that will persist post-pandemic. And in fact, there are a number of let's say, large multinational companies that have already announced that this will be something that they intend to allow in the future. We've also seen that there are some countries that are seeing this rise in remote work as an opportunity, to attract so-called digital nomads, so whether it's free remote working freelancers or potentially even employees, with a number of tax incentives being proposed in the last couple of years. And final point on this slide, but I think I've mentioned this already, we've been focusing quite a bit in the last 2 years on the mobility of employees. It's very important, and that's where the big changes have been happening with teleworking. But again, there are other parts of the population that are highly mobile and that we shouldn't forget about. Yep. So there are two very broad types of mobility that have attracted attention in recent years, and I think it's very important to distinguish them because they're just fundamentally different. The first one is what we could refer to occasional cross-border remote work, which would typically involve an individual being abroad for less than 120 working days or less than 183 days per year. For this type of occasional cross-border remote work, the main focus has really been businesses demanding more tax certainty, and in particular ensuring that this type of occasional cross-border remote work doesn't lead to the unintended creation of a permanent establishment and other income tax and social security related issues. The other important category of mobility, and very different, is more permanent cross-border relocations. So this would be situations where the employee's tax residence ends up being different from the employer's tax residence. That's one possibility, or the mobility of highly skilled workers and high net worth individuals that change countries and change tax residence. Those two types of mobility are widely different in nature, but also in their tax and their also potentially economic and social implications. So important to distinguish those. Beyond the two broad types of categories, occasional versus permanent, there's obviously a wide range of scenarios. This is far from an exhaustive list, but it's just to highlight that mobility means a lot of different things. So we talked about the fact that you can have employees engaged in either occasional or permanent cross-border remote work. You may have self-employed workers, freelancers involved in cross-border remote work. You may have self-employed workers that move from country to country throughout the year. There is the important case of cross-border commuters, and I think our colleague from the European Commission will talk about this. And then there's the mobility of highly skilled workers, high net worth individuals. That doesn't necessarily, there's a cross-border mobility, but not necessarily a remote work element for those categories. So the increase, and I guess that's why we're here today, the increase in the cross-border mobility of individuals obviously raises many tax issues. And that is because the physical presence of workers and individuals are a key determinant of applicable tax rules. If we start with corporate income tax, nexus and taxing rights, depending on the circumstances and the activities that are performed, an employee teleworking abroad may lead to the creation of a PE for the employer. There is also a question as to what the implications of senior executives working abroad mean for company residents or for the place of effective management. So very important implications. On this front, there are also potential implications of cross-border individual mobility on transfer pricing rules, in particular regarding income allocation rules if key risk controlling and decision-making employees telework abroad. The idea being, how do you allocate income when key risk controlling employees that are formally hired by an entity in one jurisdiction are physically located in another jurisdiction, and that's where they perform their functions. And there's also a more practical question, which is how can decision-making processes that are key for income allocation be tracked in a context of highly mobile work? So that's for the corporate tax implications. There are also obviously major implications for individual taxes, for personal income tax, and that is because in many countries, most countries, treat an individual as tax resident if that individual is physically present in the country for a certain number of days in a given year. So obviously major implications for tax residents, but also for taxing rights over employment income, because employment income is very often taxed where the work is actually performed. Where individuals are liable to Social Security contributions and entitled to social benefits will also likely be affected by cross-border mobility. And this may also have big implications for employers that may be required to remit Social Security contributions in the country where the remote employee is based. So all of that is, of course, major tax implications, but also big challenges from an administrative perspective, in particular in relation to the availability and reporting of information. And so one question is, do we need, with this increased mobility, do we need more systematic exchange of information arrangements to cover some of these mobility scenarios? There are also, from an administrative perspective, questions about where workers and employers are in different jurisdictions. Could we have systems in place that are low burden and allow for cross-border withholding and remittance arrangements to deal with those situations? And then also related to that is whether there might be relevant technological options for automating cross-border personal income tax. So those are some of the key tax implications. Obviously tax is key. It can be a driver, but it also has many implications. But this slide is just reminding what we probably know, but it's good to remind everyone that cross-border mobility is influenced by many other factors. So again, tax rules are one of them. In some cases, they may encourage certain types of mobility, and in some cases, they may discourage other types of mobility. But there are other factors. So technology will be an important driver of whether or not cross-border mobility is easy. Time zones is another one. Immigration laws, labor laws that may apply to individuals or their employers. So various factors. And the combination of those factors means that the opportunities and the obstacles to mobility will likely vary. They're going to be uneven. They're going to be uneven across countries, so it might be easier where there's freedom of movement. Opportunities for cross-border mobility will also depend on sectors. Obviously, easier for service sectors, or actually some service sectors where physical interaction is not as much a necessity as in other sectors. Companies also will have different opportunities and obstacles to cross-border mobility. It might be easier for large MNEs to allow a cross-border remote work than for smaller domestic companies, and then also different opportunities between individuals or types of workers. If we consider more permanent relocations where there is actually a change in individual tax residence, it might be much easier for a self-employed worker than for an employee, given all the tax implications and other implications that that would have for employers. So I will end this presentation with some of the potential implications, wider implications of increased cross-border individual mobility. And before getting into some of the risks or the challenges that we might be facing, it's probably good to remind ourselves that there are potential benefits associated with increased cross-border mobility, whether it's from an economic, a social, or an environmental perspective. So for instance, increased flexibility, labor participation, and well-being might be positive consequences. Remote work may have environmental benefits if it means reduced traveling, but that may not always be the case. Another benefit that's not on the slide, but that's obviously important to mention, is that for businesses, remote work may imply significantly reduced costs compared to the traditional brick and mortar type of office model. So some potential benefits that are important to highlight, of course. Now, there are also some risks. A key one is a potential decrease in tax certainty and potentially also in tax compliance, especially for specific categories of taxpayers. And I think tax certainty will be a key priority for businesses. Another important risk is the potential increase in personal income tax competition, and that applies more to the case of more permanent relocations. But this is indeed a potential risk. Sort of associated with that is potential revenue impacts that may be quite significant. Just to remind everyone, personal income taxes and Social Security contributions, if we look at the OECD on average, they're about 50% of total tax revenues. So much higher than corporate tax revenues, just to remind everyone. Hence the importance of this topic. But of course, mobility, whether it is more permanent relocations or occasional cross-border work, may also affect other tax bases. We talked about corporate income tax, but it may also affect consumption tax bases and property tax bases. There are also important distributional effects. Not all individuals have the same opportunities to engage in remote work or global mobility, and we just also talked about the fact that not all companies, not all sectors, and not all countries will benefit equally from this, so this means distributional effects that we need to consider. And then there may be an impact on the structure and the financing of social protection system, in particular if we're starting to see mismatches between public investments and the benefits and contributions made by individuals. I'll just conclude with two remarks, one which is quite obvious, but good to restate. There is definitely a need for tax system adaptation, and looking at the individual side of things, these were systems that were conceived pre-digital era, so definitely a need for adaptation. Second key message is when we talk about cross-border mobility, this means a whole range of different things, right? Very different scenarios. And one question that we can ask from a policy perspective is, are there types of mobility that the tax systems should facilitate, should definitely not impede? And then are there types of individual mobility that we might want to be more careful with because they may bring higher risks of tax competition and potential revenue erosion? So I will stop with this, and I look forward to hearing the presentations of my colleagues today and tomorrow. Thank you very much.
I'd like to thank Sarah for this presentation. Our next speaker is Patricia Brown, Interregional Advisor on Tax Matters of the UNTax Committee. Also, although she corrects people in this, once a professor, always a professor. So, Professor Brown, please.
Thank you, Sveti, and good morning, everybody, and I guess afternoon and evening for those who are here virtually, which is appropriate for this conference. I need to perhaps, and I apologize if you know all this, but I think it is worth introducing. And now I support the UNTax Committee. I am no longer on the UNTax Committee. I am on the Secretariat of the United Nations, and the UNTax Committee, I think it may be a little mysterious or unknown to many of you. The Tax Committee consists of 25 individuals who are nominated by their governments, but who serve in their personal capacity. And that has been the system since 2005. And it actually, as I put together this presentation, it became clear that that form of governance has affected how the UN model has changed over time. So before 2005, the model was developed by an ad hoc group of experts who were nominated by their governments, but there was no regional or geographic representation, no division between developed and developing countries. So, so you'll see through the presentation that things have changed from that model going forward. Now, when I was asked to do this, I interpreted the question I was supposed to answer is, what do developing countries want? And luckily,
You pointed this.
Point to. Okay, what am I pointing to? Okay. 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 Sorry.
Try it. Worked. A couple minutes more. Maybe it's better.
Okay. Well, at least the technical people can't make it work either, so I don't feel quite as bad. Well, luckily for the answer to answer the question of what do developing countries want, we actually had, there we go. Thank you.
Right.
Okay. We actually asked them. In April of 2022, we had what's called the ECOSOC special meeting between the Tax Committee and the ECOSOC, the Economic and Social Council. And we have some key messages. So, and this was in connection with the future of the corporate tax system, but these basic messages, I think, are the same with respect to taxation generally. So, of course, the first point is that the rules have to be flexible enough to keep up with changes in business and technology to ensure effective taxation of economic activity and value creation. That's hard to argue with that. But then the second point is that it has to be inclusive norm setting, which means it has to respond to the needs of economies at all levels of development, which means with all levels of administrative capacity. The rules should be easily implemented and administered by all countries. And I think this is the message that we hear most often within the discussions at the tax committee, right? Complicated formulas don't work for most developing countries, which means that they generally prefer simpler and more administrable approaches, which leads to Article 12A on fees for technical services, which was added to the model in 2017, and 12B on income from automated digital services, which was added in 2021. And developing countries want accelerated modification of existing tax treaties. Now, I need to step back for a second because most developing countries, we spend a lot of time talking about the tax treaty rules. But the fact is, most developing countries don't have a lot of tax treaties. And so you're really relying primarily on domestic law and then looking to, tax treaties simply restrict what they can do in their domestic law. And I think that this is a point when we talk about Pillar 1 and people talk about that being a new right to tax, for developing countries, that's not true because the developing countries have never given up the right to tax because they haven't entered into tax treaties. Now, in many respects, and a lot of people talk about the fact that tax treaties are 80% the same from one to another, but the really interesting part is the 20% that's different. And when you look at the UN model, a really surprising amount of the differences between the UN model and the OECD model have to do with services. And this goes back even to the beginning. Now, these provisions, I think, were all put in when the UN model was drafted by the by the ad hoc group of experts. And so you'll see that most of them are expanding net basis taxation. So the model has retained and retains to this day Article 14 when that was deleted from the OECD model. The services provision of Article 5.3b, which includes deletion of the same or connected projects in 2017, but that's been in there for decades. The insurance provision of Article 5.6, which allows taxation as a PE if insurance premiums are collected in a country. Articles 7.1b and c, which applies both to the sale of goods but also services, but expands. And it's interesting because every time I do a workshop with my friends from the OECD, they keep referring to the limited force of attraction in B and C. And I said, that's not really limited. It could be quite broad. 7.5 was never adopted in the UN model, which limits the attribution of profits with respect to the mere purchase of goods or merchandise. And then there's the shipping provision of Article 8, Alternative B, which has a form of formulary apportionment. Now, it's interesting, you've probably never heard of Alternative B of Article 8 because nobody ever uses it in the treaties. And why is that? Well, because a lot of developing countries can't impose tax on a net basis. So even though they have taxing rights under Article 5 or other provisions, it's very hard to exercise them and collect any additional revenue. So once the ad hoc group of experts was replaced by the committee of experts in 2005, some of their first activities were to look at services and mobility, because this has been an issue for developing countries for decades. So in 2008, they established the subcommittee on Article 14 in the taxation of services. The new memberships last for 4 years. So that was the last meeting of the first membership of the tax committee. And at the beginning of the next membership, they established the subcommittee on services. That's also been a major focus of our capacity building activities. There was a handbook on selected issues and protecting the tax base of developing countries, a practical portfolio on protecting the tax base of developing countries against base erosion, income from services. Adolfo just told me there's one on royalties that I didn't know about. So I'm looking forward to looking at that. And there were 4 workshops that focused on BEPS issues relating to developing countries. And the focus, if you think about the BEPS project at the OECD, the focus was not primarily services, whereas there was quite a different focus in developing countries, which reflects the fact that the UNTax Committee is really focused on solving the problems of developing countries, which has not traditionally been the focus of the OECD. They're expanding their focus, but I know when I was consulting for them on the TRACE project, we were trying to solve the problems of developed countries. Okay. So what has all this focus led to? Well, now, if you look at the provisions that have been adopted, some of them before, but more recently, there's more of a focus on gross basis taxation, withholding taxes, albeit at a lower rate, right? So there's not, before it was stated that one of the goals was to achieve net basis taxation, but now the way they do it is a withholding tax at a relatively low rate. So there has always been a broader source taxing right in Article 12. It applies to equipment leasing. But in 2017, we added Article 12A, as I mentioned, on fees for technical services. Article 12B on income from automated digital services went into the model in 2021. Now, this is interesting because Article 16 actually applies to employees, to top-level managers. So it is one of the cases where the UN model has gone beyond just looking at independent contractors or services provided by corporations to deal with mobile top-level managers. We have the pensions article, has allowed taxation by the state from which payments are made. And Article 18 has allowed source taxation of payments under the Social Security system, right? So the UN model has shifted from expecting developing countries to tax on a net basis to the more administrable provisions of withholding taxes. And it's important to note, again, because we're not just looking at the model, there are some countries, developing countries, that have done this all along. So, for example, Brazil has never used an expanded definition of permanent establishment. They've always relied on high withholding taxes. So this is where the UN model is. Now, where is the model going? Whoops. No, it's there. So there are there are many subcommittees in the UNTax Committee. This is the work of two of them that are directly relevant, I think, to this topic. And that is the Subcommittee on Taxation Issues Related to the Digitalized and Globalized Economy. We don't have short titles for our subcommittees. So there are two work streams in that subcommittee. I'm not the focal point for this subcommittee, but Michael Leonard is. The first work stream is on multilateralizing Article 12B and possibly other provisions. And the provisions that they've talked about are possibly 12A. We are working on a subject to tax test, maybe offshore indirect transfers, which are outside the scope of this. But the focus has primarily been on 12B. Now, the second work stream is on considering the relevance or otherwise, very interesting two words there, of physical presence tests. And we already have the technical services provision. We already have automated digital services. So the question is, where else do we have physical presence tests in the UN model? And that is obviously Article 5.3b, 5.3c, which is an alternative, and Article 14. Right? So those are some of the places where that workstream B might be focusing on going forward, which means we're edging in N15. Right? So we're sort of edging into some of the employee areas. Now, the subcommittee on the update of the UN model, what are we looking at? And I am the focal point for this. We're looking at taxation of income from shipping. Now, I said before, we already have a provision that expands alternative B of Article 8, actually expands the taxation of, or provides a source state taxing right to shipping. So why are we looking at it now? Well, as I said, nobody actually uses that provision. The countries that do have source taxation of shipping generally do some sort of withholding tax. And so the committee has considered the fact it doesn't make a lot of sense to have an alternative provision in the UN model that nobody uses. So we're going to consider putting in a provision that somebody might actually use. Taxation of cross-border insurance activity. It's really hard to tax the net income of insurance companies because they are incredibly mobile. And so even countries that put the PE provision in, or put the insurance provision into the PE article frequently cannot collect much tax from that. And so we're considering alternatives to that. We are working, the UN model now has a mix of provisions that have a physical presence requirement and some that don't. And it's not always clear what activities fall within one versus another. So we have started trying to clarify which activities fall within which articles, and that'll probably be, there'll be additions to the commentary. And then this is sort of a really technical issue, but it's important and it's come up in some cases. And so it's described as the interaction between 21.3 and the source rule of Article 18. That's not what it's entirely about, right? So the UN model, as some of you know, a lot of you have never paid attention to it, Article 21.3 of the other income article, first two paragraphs look like the OECD model, and the third paragraph says, however, if the income arises in the first state, the source state can tax. But we don't have a source rule in Article 21. So, and the reason we refer to it, Article 18 is just one, we've just modified the source rule in 18 and have identified there might be a conflict, but that's not the only possible conflict. So for example, if you have, some of you might recognize the case, but I'll make it a hypothetical. If you have a celebrity, an actor, let's say an actor, who performs services outside of a country, right? So it's an actor from country A who performs services in country B and is paid by country C. Well, can country C tax? Well, you might be another income, which means you don't have a source rule. And there are a lot of countries in the world whose source rule is if it's paid by our resident, it's sourced in our country. And so not having a source rule in 21 could create some problems for some of the mobile actors that we're talking about in these couple of days. So I think I've used my 20 minutes. So, and I think I am done. So thank you very much. I look forward to talking to you all.
One of the reasons why it's very useful to have conferences like this is that you actually start getting ideas as we speak. And for example, I think probably a lot of you haven't thought about much about this. Some people here I'm looking at Giorgio Perret, I know he has. But Article 18 and pensions were mentioned, and actually, when we talk about the mobility, one of the big issues will be the mobility, the migrations of the elderly that we are already expecting and will be actually seeing with these immigrations for certain countries. And once people come of pension age going back to the countries of origin. So this is again another aspect of mobility that is, I think, sometimes easily overlooked. But enough from me. Thank you very much for this presentation. Our next speaker is Albert Raedler from, sorry for my pronunciation, from the European Commission. And please, the dais is yours. Thank you.
Voila, good morning, ladies and gentlemen. Thank you very much for the invitation. The subject of the conference is the issue I've been following up for the last months. So I'm very happy to come here to present our views and also some suggestions and solutions to you. So when we accepted the invitation, this was back in June, we were quite optimistic to come here and to have the rollout of a brand new Commission initiative. Unfortunately, you might have followed the press, there is nothing. So I'm sorry, I would have wished to come here with some very nice papers, very nice ideas, but I don't come with empty hands because I can speak here for presenting you our views on what we thought to do with to remove tax barriers for citizens. So if we move on. So let's start with the core issue of the Commission initiative to remove tax barriers for citizens. Teleworking has been around, has not been used too much. And now we all agree COVID has completely changed the mindset. Teleworking is likely to stay and will be an essential part of the working life in the future. My presentation will cover the following issues. I need to say, we've seen here different points of view out of the perspective of the Commission, of the European Union, and in particular of the internal market. Please have that on mind. So how did the pandemic affect frontier workers, cross-border workers with regard to cross-border teleworking? Since teleworking will continue to be widespread after the pandemic, are the tax rules in place appropriate and what we like to call fit for purpose? If not, what could be alternative solutions? So here we are. First, let's have a quick look at the underlying numbers. Please find here a slide indicating the number of incoming cross-border workers. Already here, what is a cross-border worker? We have various definitions, and a cross-border worker, as we use it here, is a person who lives in one country and returns to the other one on a daily, weekly, or even monthly basis. But he lives in one and works in the other one. We base our figures on the annual report on labor mobility, which provides vast information on any kind of cross-border working. These are our colleagues from DG Employment. You will see here, we've got 400,000 people commuting into Germany. Here, and then we've got very important Switzerland, Luxembourg, Austria, Netherlands, UK now, it's pre-Brexit, Belgium, Italy, and then the number go down. Germany, of course, border regions. This is from Poland, France, Belgium, Netherlands, Denmark, but also from Czech Republic. In particular, this might be surprising because you see Switzerland and Luxembourg with very high numbers of incoming commuters. In particular, if you take into account the size and the population of the country, we have more or less the same number of people commuting into Luxembourg than actually Luxembourgish people working in Luxembourg. And that doesn't work. Ah, there. Ah, no, wrong button, sorry. And then the next slide. Where do they come from? And we have here more or less the same number, around 400,000 people. They live in France and commute to mainly Switzerland and Luxembourg. And here we've got the same issue for Germany. Germany has many borders, high population. They commute to Netherlands, Belgium, France, of course Luxembourg, of course Switzerland, but also Austria. Then we've got here quite prominently Poland, Romania, Slovakia, Hungary. Here you've got Hungarians, Slovakians who commute into Austria, probably on a daily or weekly basis. But here it is very clear that the Polish, Romanian, they will commute to other member states. They will commute to Germany, France, at the time also England, and they definitely will not commute on a daily or weekly basis. So the cross-border workers issue, the who and where, it is not a widespread European or global or European-wide issue. It's an issue of the border regions and with hotspots. Not any border region has a cross-border remote issue or remote worker issue, but we have got here what we like to describe as hotspots. So definitely we have a huge big hotspot in the Grande Région. This is Luxembourg, France, Belgium, and Germany. We've got the German border regions in general with Poland, Czech Republic, Austria, France, Luxembourg, Belgium, Netherlands, and Denmark. We've got also a very important hotspot in Austria, the Vienna region with Czech Republic, Slovakia, and Hungary. And then we have got some smaller ones, which is the Greater Copenhagen area with many Swedish residents commuting into Greater Copenhagen. Also Estonia and Helsinki. We've got many Estonians who commute, not on a daily basis, but what I heard, they commute every 2 to 3 days by boat to Helsinki. And then, of course, not as an EU member, Switzerland very prominently, very, very prominently with very high numbers. If we look into the numbers, we've got around 1.3 million cross-border workers. Again, these are people who work in one country and live in the other one. There are an additional 370,000 commuters for EU EFTA numbers. And the statistics, however, do not show one figure which would be of particular interest. What is the share or even the number of teleworkers amongst these cross-border workers? Would a 50% of teleworkable jobs be appropriate? Then there would be a number of approximately 800 cross-border teleworkers. We do not know, but there is clear evidence that the issue of cross-border teleworking is of high concern in the hotspots mentioned above. Let's see the underlying issues in taxation. Cross-border worker will be active in 2 member states. In the one member state in which he actually works, and in the other one in which he lives and in which he performs his home office. So it is a case of the application of Article 15 of the respective bilateral double taxation convention, which will determine the taxing right between the 2 parties. According to Article 15 of the OECD Model Tax Convention, the principal right of taxation of employment income is the state of residence. Article 15.2, I don't want to go into technical details, but in principle only grants in a subordinary fashion the taxing right to the state of source, in principle or in particular if the person works more than 183 days in the other country. There are other situations, but if we take our baseline scenario, we have got one person living in Germany, commuting to Luxembourg every day, there's taxation in Luxembourg, no doubt about those. But if the person now starts to work in home office, the attribution of the taxing right, because the state of residence has the primary taxing right, it is already the very first day of home office which will trigger the taxation in the state of residence. And this will mean, in principle, every day of such a cross-border teleworking, we've got an apportionment of income for taxation purposes. And if we go quickly through the consequences for the employer, and this is already here, the word which we like to use, the apportionment will be the origin of tax repercussions, why many cross-border teleworkers who could telework, but finally don't do because of these taxation consequences. For the employer, we've got an apportionment of income in 2 jurisdictions. Already compliance issue. He needs to levy the wage tax, of course, in the source state. But is there an additional obligation to levy withholding taxes in the state of residence? How is it organized? Question mark. For the employee, we've got additional compliance issues, obligations for the cross-border teleworker, because he needs to file 2 income tax declarations, one in the state of source, the other one in the state of residence. Now, a point which is extremely important, at least from an EU point of view, is the apportionment may lead to a situation where the person falls below certain thresholds. There was the judgment in Schumacher, and in Schumacher said you receive tax benefits if you receive all or almost all of your income in the source state. Now, if he starts teleworking, he might go below the threshold, which is normally at 90% or 75% of the worldwide income of the residents. So if he falls below these thresholds, he will lose tax benefits, and tax benefits can be substantial. And then a third point is possible impact on the overall income situation, depending on the question of who levies social security, where do you pay your income tax? There is a very interesting study from Professor Verlinden from the University of Maastricht. She made a simulation for a gross salary of 55,000 euros. The net amount of the different simulations can be the difference of net amounts can be up to 7,000 euro nets on a 55,000 euro gross salary. So there can be massive consequences for the net income, for the better, but also for the worse. And if it's for the worse, you can be sure that there won't be any cross-border commuting in this area or cross-border teleworking in this area, in this direction. Also, for the tax administration, the tax administrations will need to more or less deal with the same issue. It's always the question about how many days did the person stay in the 2 countries. You need to assess the same taxpayer on more or less the same issue. There's a risk of double taxation. How do you manage the assessment of the taxpayers? In theory, this can work very well. In practice, we all know this can lead to effective double taxation and tax disputes. In any case, there will be increased compliance for everybody. So how did citizens, well, we go on. How do cross-border teleworkers or how do citizens react on such tax repercussions? We are waiting for the outcome of studies, but we've got anecdotal evidence that citizens tend to prefer to commute every day instead of having the obligation to file tax declarations to countries, and also to have unpredictable tax consequences because, for instance, they burn the threshold or they have effects on the net result. And if somebody ever has been in the Luxembourg area, people commuting into Luxembourg, this is not a pleasure. Oof, this is tough, huh? The effect on companies. Again, we don't have the full picture. We have, however, anecdotal evidence. We've got one large German stock corporation which formally prohibited their employees to telework from abroad. Teleworking in Germany, yes, from abroad. Formal prohibition because of legal risks in the area of labor law, social security law, and tax law. I don't know if this still continues because my impression would be the company is not really attractive for new hirings. Huh? So I'm not sure how companies will deal with this issue if they can afford to actually preclude their employees from doing so. As we always know, or as we always listen from the outside, that remote working is one of the main issues what young people want to have, what they ask from their employers. So this sounds very difficult, very bad, but the situation is not as bad because there are derogations to this system or to these principles. First, The common denominator of these derogations is always the same. It is the avoidance of apportionment. We've got this apportionment, which is the crucial issue why we have these problems, cross-border teleworking in the EU, in the internal market. First, we have some double taxation conventions which provide for de minimis thresholds. This means there are certain days within the year on which they do not have to show up at the work in the other country. And this does not trigger the apportionment and the taxation in the state of residence. The numbers are not very big. There are, for instance, 19 days for the double taxation convention between Luxembourg and Germany, and covers missions abroad, trainings abroad, but also teleworking. And here, 19 days is not even 1 day per week over the year teleworking. There are other examples. They go up to 34. It's between Luxembourg and France, for instance, or Luxembourg and Belgium. 34 days of teleworking, again, better than nothing, but it's not even 1 day per week. We've got specific cross-border commuter provisions under these specific conditions. A few double taxation conventions provide for the taxation in the state of residence for frontier workers independently if the citizen works at the usual place of activity or in home office. I mentioned here the double taxation conventions between Germany and France, Germany and Switzerland, Germany and Austria. And then we have the crisis measures. We have seen all these effects and what was in the crisis. And we have had quite a number of temporary crisis measures in which member states bilaterally agreed that teleworking due to COVID is a force majeure, and the days spent in home office are deemed to be days spent at the normal place of activity. But these rules, to the largest extent, expired as from 30th of June 2022. And so here again, we are waiting for the first reactions, first results. How do citizens react on this new reality? Meaning home office triggers apportionment, home office triggers the additional compliance burdens. Now, this is probably the most interesting part, at least for me. What can be done? How can we solve this issue? We also have to mention here, these are solutions which are based on our EU perspective. We are targeting, or we are addressing these tax obstacles, and we are looking for targeted measures. We need to go to the OECD if we want to have a bigger picture and have a kind of a new rethinking of Article 15. This is not our purpose, this is not our task. We look here for quick fixes, but we need here changes of double taxation conventions. So this is not a quick fix, but at least it is targeted. So the first one would be setting the minimis limit. If you have at least a certain number of such de minimis days, it already would help. Numbers would not go too high, these numbers of days, but at least it would be better than nothing. Here we have also the reaction of the German government on a written question from a member of parliament. And here the German government clearly stated 24 days would be the maximum what they could consider to be appropriate. 24 days, it is half a day teleworking over the year. So number two would be setting a de minimis limit aligned with Social Security threshold. And here, again, we have heard about the Social Security dimension. Have in mind, there's another threshold coming in from the Social Security side, because under the coordinated Social Security regulation, it is a regulation, the Home Office performed in a substantial part of the employee's activity would trigger the change of the applicable Social Security system. So substantial would mean 25% or more of the time spent or of the remuneration attributable to the state of residence. And in this case, normally the applicable social security system would change. And I can assure you, any employer would say at this moment, at the latest, no, I don't do this. This is too much compliance burden for our services. So we have got 25 days, 25% of the activity, which would amount to approximately 55 days. And then we come to our preferred option, which would be a one-stop shop. So our employee is only taxable in one state, can be the state of source. It would be, in our views, ideally the state of residence. Why ideally the state of residence? Because then the employee does not have any tax obligations in the other source state. One-stop shop means it is only one tax which is applicable. It is only one tax base which is necessary, and there's only one tax administration in which the person has to deal with. Of course, this can have an impact on the budget for the member states. But if we go from a point of view, an ideal world, a perfect world, you would have as many people commuting inbound as outbound. And in principle, the numbers should be neutral. So you wouldn't need any issue to equilibrate this. But you know all, we don't live in a perfect world. Take the numbers from Luxembourg. In Luxembourg, we have got one person living in Luxembourg, commuting outbound, and we've got 30 persons commuting in. You know exactly their imbalances. This is not the end of the one-stop shop, because the one-stop shop could be accompanied by financial compensation arranged, agreed between the member states, which would cover the situation. So this would be, if I could dream, this would be for me the ideal situation. This may sound like tax science fiction. However, it is not, because such one-stop shops already exist. Such one-stop shops also with financial compensation. Also have in mind these de minimis limits. As long as you work in within the limits of these de minimis limits, you have a one-stop shop, because there's no apportionment. Here, the examples which we have for such cases of a one-stop shop with financial compensation is the Öresund agreement between Denmark and Sweden, where Denmark agreed to reimburse to Sweden the amount of communal tax due in Copenhagen for the Swedish residents who work in Denmark. We've got the German-French double taxation convention on the taxation of pensioners. Have a look in this. This was amended in 2015. We had big troubles. We had a lot of, again, anecdotal evidence that there was a huge big problem, but this had been resolved by a one-stop shop. The pensioner is only taxable in the state of residence, and if there's an accident, it is the member state who earned more will reimburse to the other one in a very clearly predefined manner. And then we've got at least also, happy to say that too, because I heard some Swiss German over there, between the German and Swiss double taxation conventions, workers living in Germany are only taxable in Germany in the state of residence, but Switzerland levies a gross withholding tax on the gross salary of 4.5%. Please correct me if I'm wrong. So where had there been other initiatives? Yes, I agree, difficult to find, but there had been several initiatives. Here, have a look at these issues. We have from Benelux. Benelux, the institution, the organization is alive and kicking, working niches, but they are doing very interesting issues. They issued a recommendation in 2021 to align the income tax and social security obligations of frontier worker and introduce the minimis limit of 48 days, which would be 1 day per week. We have the Assemblée nationale, Résolution européenne, which asks for 96 days. We've got a petition to the German Bundestag for an alignment of cross-border teleworking with the social security standards. We already talked about that. This would be around 55 days. And finally, we've got our own initiative opinion of the European Economic and Social Committee on taxation of cross-border teleworkers and the employers. These all issues you can find on the internet. In particular, the last one's very interesting. There's a lot of additional reading if you're interested to follow that. What have we been doing? Well, we had received so many calls from outside, member states, stakeholders, citizens. We had been discussing this repeatedly with member states. There was a Commission Working Party 4 in September last year. There's a platform of good governance meeting. This is published on the website. Have a look if you're interested in the working document. There were discussions informally with heads of tax administration. Have a look in the annual report of taxation. And also here, if you're interested to dig in, written replies from the commissioner to questions from the member of the European Parliament. Here we already kind of disclose what are our plans. There should be very soon another written reply be published. We have to say all the other institutions, the direct effect, well, there is none. We have to be very clear on that. Benelux recommendation, Assemblée Nationale from France. It is a Résolution Européenne, petition to the Bundestag, own initiative, opinion of the European Economic and Social Committees. Very sound papers, but in the end, there's no hard law. And then we come to the options for the Commission action. What can we do? It's a difficult scenario. Any tax issue for the Commission is a difficult scenario. We've got unanimity. Unanimity is practically impossible to achieve. So the issue is dealt by member states in bilateral tax conventions. Bilateral tax conventions are a compromise. Any article is discussed, agreed upon between two member states. We have received repeatedly the very clear message that member states do not appreciate very much if member states would mingle in this bilateral turf of member states. Proposal of a directive. This is technically spoken to prepare a proposal, not the most important thing, not the most difficult issue, but of course, it would then go to the council, and in council, we again would need unanimity, and we all know with 27 member states, it is very difficult, I would even say in this matter, impossible to achieve. And then we come, what is hopefully our action, which will be published. I would be amazed if it's still this year, so it will probably or hopefully be beginning of next year. It's a recommendation on removing tax obstacles for citizens. And this is here a quick tour de table. I think it's a little bit more than 20 minutes. Excuse me for that. Thank you for your attention.
Thank you very much for this presentation. I think it's also quite befitting that actually the idea comes to mind that a lot of the issues that are facing the European Union are actually being dealt with within the United States at the level of state taxation. It comes to mind we have, I think, 3 New Jerseyites on here present. I'm a former New Jerseyite, and it's Telebrite, the case Telebrite before the New Jersey Supreme Court, which actually dealt with some of the issues that we just talked about. So this interaction between various meridians, I think, can also bring in good results. That being said, I would like to give the floor to somebody that I have the honor of calling my teacher. It's Professor David Rosenbloom from New York University and also a partner at Chaplin Drysdale. Professor Rosenbloom, please.
Thank you very much, Sveti, and thank you for the invitation to this conference, which I think is a terrific idea. I absolutely love the topic that I've been asked to speak about, which is the academic importance of the general topic of the conference, because it gave me a bit of an opportunity to think about what the Tax Academy is up to and what I think it should be up to, which is not necessarily the same thing. Let me say, by way of introduction, I am very much a professor. I've been teaching in law schools for nearly 40 years. I've taught in 5 U.S. law schools and probably 15 law schools throughout the world, pretty much on all continents, including Africa. Um, and so I am very much in the academy. I'm also a practicing lawyer, and I've been that for even longer than I've been an academician. So that gives me a certain view on things. I should disclose a couple of biases of my own, which I think are probably out of sync with the views of most people in this room. I am very skeptical about the existence of an international tax system. My experience tells me that that's largely imaginary. I think that runs counter to the beliefs of most people, but in practice, I think what we have is at best a system of harmony among countries. I think treaties contribute hugely to that. I'm a great fan of tax treaties, and unfortunately, in my own country, the United States, treaties are quite under attack for a variety of reasons. I would also say that my remarks are heavily influenced by my own experience, which is all largely United States experience. I don't know much about what's going on in Europe. I was interested in Mr. Raedler's presentation, but I don't follow what's going on in the European Commission very closely. So with saying that, all that by way of beginning, let me see now if I'm going to be able to master this. Oh, you do it this way. There we go. So, from my perspective, um, uh, this is pretty obvious, I think, if you think about it. We're not talking about sociology or philosophy here. We're talking about a very practical uh, topic, which is taxation, and uh, taxation really has to be interpreted in rules. It's a rule-based discipline, and we have to have rules that people can follow and that tax administrators can administer and courts can apply. And tax policy is not unimportant. I certainly am not an enemy of tax policy, but I've heard far too much tax policy without any kind of connection to what the rules implementing the tax policy might be. It's a lot of fun to think about, what we would put in place if we ever colonize Mars. But in the meantime, we have to deal with the real world, and there's a lot of work to be done on simply understanding what the rules are and how and why they might be changed. And in my view, at least in the U.S., the academy has gone because the rules are difficult. The academy has gone way too far in the direction of sort of stargazing about rules and what might be the law if and when, and has sort of neglected. I'm talking about the U.S. now, the job of teaching students who, after all, are going to be themselves practitioners and professors, and they're going to be living in the real world, what the rules are and how they might be changed. Now, so I have a beef with the academy. I think that the law schools in the United States have suffered and possibly elsewhere. I probably could speak about other jurisdictions, but in the United States, certainly law schools have veered way too far toward broad philosophical approaches to issues. rather than practical approaches and what rules might actually be put in place to deal with cross-border issues, which is what we're talking about when we talk about international taxation. Now, of course, digitalization, as we all know, has put a lot of pressure on the international tax rules because of mobility. I agree completely that there's been much more attention paid to mobility of corporations than mobility of individuals. And for that reason, I applaud the organizers of this conference. I think this conference is an important step to remedying the imbalance between attention paid to the corporate world and attention paid to individuals. I'll come back to that in a second. I do think that individuals, as my outline suggests, I do think that individuals pose more and more difficult problems because corporations, to my way of thinking, have a residence. That's sort of an anchor. Now you can debate what the residence should be. We lots of there's different definitions of residence, and some of them are better than others, and some of them have got advantages and disadvantages. And I think that debate's been going on for decades. I'm not sure myself that the digitalization has changed that debate all that much. But it is an anchor. I mean, ultimately, corporations have a residence. Individuals, to my way of thinking, don't necessarily have the same kind of an anchor. Um, sure, every country's got a definition of individual residence, but individuals can, and in the modern world, do have more than one residence in their lifetime. And to my way of thinking, the result is that the issues that affect mobility of individuals are even more complex and than the issues pertaining to corporations. And it's also worth pointing out that when we talk about mobility of corporations, we're talking about a relatively limited number of taxpayers, whereas individuals, obviously, we're talking about multitudes. So I think that the issues affecting individuals have been around for a very long time. And this conference certainly evidences attention being paid to that. I would cite also work of one of my colleagues in the law firm where I work in Washington, Elizabeth Stevens, who wrote a terrific article called "Where the Money Is: Tax and Worker Mobility," published in Tax Notes International on August 1 of 2022. Liz goes through a range of issues. And the issues, I recite them briefly there in the outline. There's the jurisdiction to impose tax in the first place and avoidance of double taxation, which Mr. Raedler also referred to at some length. Profit attribution for purposes of source country tax and compliance obligations. Those are also major issues worthy of being explored. There are transfer pricing implications. There's the issue that's always interested me, namely that when an individual moves to a source country, what does that do with respect to transfer pricing? Since the individual, with respect to his employer, I think, is operating at arm's length, and presumably his salary is an index of what that individual is worth. That's a debate that I've enjoyed hearing about. It's not easy. We in the United States also have some peculiarities in this area. Perhaps, I don't know whether other countries have faced these. We have a major concern about exit taxes, the transfer of particularly intangible property outside of the United States. And we have fought for quite a while over the question of whether workforce in place is an intangible property subject to recapture of something when the workforce in place is expatriated. Then you get to the question of what is a workforce in place? Is one one employee, a workforce in place, or multiple employees, a workforce in place? What exactly does that mean? We throw around these terms, and we don't have very precise definitions. And then another issue which I would like to point out is the retirement plan question, which I have participated in sessions at my institution in New York simply on the question of cross-border pension payments. This is a gigantic area in and of itself. And it's to be contrasted, I think, with the cross-border mobility issues that Mr. Raedler was talking about, because this is a temporal question. And actually, when we talk about mobility, we ought to put out on the table more broadly, not just in the pension area. We ought to put out the question of temporal mobility as in addition to current mobility, should we say? Current mobility, I'm just making this term up as I go, but current mobility would refer to cross-border commuting, cross-border teleworking, et cetera. But temporal mobility is also a major issue, because in the modern world particularly, we have thousands of individuals who work in one country and retire to or move to another country. And that creates all sorts of issues. And the pensions is one area where I've seen it myself. It's a fairly large area. Another area where that you get the same type of question, an area that for good or for evil, the United States has been focused on, is stock-based compensation. You know, an executive works for a company for a certain period of time and then retires to another company and cashes in on his stock. That's a pretty frequent occurrence. And that raises a lot of these mobility questions, but not in the sense, it's quite different from the person who commutes across the border to Luxembourg every day. This is a different set of issues. Now, the issues, of course, play out both in domestic law and in the tax treaties. I think the U.S. has got quite an elaborate set of rules for cross-border mobility, both in the telecommunication area, but also in the pension area. We have an entire article of our model treaty devoted to the treatment of pension funds as opposed to pension payments. That's one of the more complicated articles, actually, of our model. And I think that I should say, perhaps, an area that understandably Mr. Raedler did not refer to, where we encounter the kinds of mobility issues, both the temporal ones and the current ones, is with our neighbors to the north. The U.S.-Canada treaty dealt with all these issues, and we have thousands of people crossing that border every day to work, and that's been true before digitalization. I'm sure digitalization has added to that issue, but if you wanted to talk about so-called hotspots, I would have thought the U.S.-Canada border in particular, and to some extent the U.S.-Mexico border, although I think that's probably less of a current issue. I would say that the shift in focus to individuals, which this conference reflects, is a bit late in coming from an academic standpoint. But it's clearly true that individual taxation is more important economically in terms of revenues than corporate revenue. I like particularly the Elizabeth Stevens reference to the Willie Sutton rule, the Sutton rule. Most of you probably don't know who Willie Sutton is or was. He was a very celebrated bank robber in the United States. And when he was asked why he robbed banks, he said, because that's where the money is. And that's sort of what we're talking about here. We're moving into an area where there's an awful lot of revenue at stake, and there's a dispersed target, because there are obviously many individuals as opposed to the limited number of corporate targets. So I think that what we're facing here is the beginnings, perhaps this has been coming in various places for some time, of an intellectual effort to pay attention to these topics. And I think this conference really it kickstarts the whole area, and is a very worthwhile thing to do for the academy. I'm speaking now for the academy. It's obviously, as a practical matter, it's also worthwhile. And I would say that what I would like to see in the academy is more attention paid to the identifying the individual issues and actually working on practical rules of resolution. They don't necessarily have to be with only one country. They could be for use in a bilateral or even multilateral context. But my skepticism about thinking about broad international cooperation hooks in here, and I do think that we ought to aim to really make the situation more user friendly, shall we say, and more capable of being administered in the real world. I think that's where the academy is and where it should be. My own view is that there's a great deal of work to be done here, and once again, I commend the organizers of this conference for taking on this topic. Thank you very much.
Thank you, Professor Rosenbloom. The idea when we set up the plan for the conference was actually quite in line with what you said. If you see the program, there are no national reports. Every single topic has been dealt broadly from a principle basis. So we are trying to aim to deal with topical questions which can be applied in any jurisdiction. And then once we determine what they are, then we would further go for specific national solutions. Our last speaker for today is somebody who's a well-renowned name, Isabel Verlinden. I think my pronunciation is correct. Thank you. A global tax strategy leader of PricewaterhouseCoopers PwC from Belgium. Isabel, please. What Isabel, of course, will be talking about with us is emerging issues in day-to-day practice. Please, thank you.
Thank you very much. Good morning. You saw me limping. Too much mobility means you take the risk of being hit by a car when you're cycling, so be careful. Thank you so much for having me here. Thank you, professors, for inviting me. Professor Kostić, do I pronounce it right? You invited me quite a while ago, I think, Albert. You said in June. I think we talked a year ago. And it was, are you in to come to Belgrade? Yeah, why not? Good thing. And the panel is about setting the scene. And I thought, wow, this is where I need to be as a consultant. You only have to raise problems and issues, and then the academics come in to solve them. So a little disclaimer to start with. And then I think I can say Sveti by now. Never go to Belgrade. If you have eaten already, don't eat for 3 months before, because but it's quite an experience. So thank you so much for that. And another disclaimer, because I'm here to talk about issues in practice. I'm just one practitioner. I'm very much a one-trick pony in transfer pricing, to be honest, and I do appreciate that in economic terms, the corporate tax issues might not be that relevant compared to what's at stake, as Professor Rosenbloom was saying. Nevertheless, and I'm going to be a bit naughty here, I'm picking a bit up on what you said, David. I sometimes have the impression that some tax authorities think that all companies are Willy Sutton Incs. Or limiteds. And this is what I'm going to talk about a bit. It's about business models are not as flexible as companies, as tax authorities might think, and that has certain repercussions. What I mean by that is geopolitical challenges. I don't need to talk about that. You know that much better than you, because I'm by far the least qualified person in the room. I appreciate that. But I picked a couple of things from publications like Harvard Business Review, The Economist, and you can go on. And what I experience in practice is that when you talk to clients, when you talk to successful startups, successful large multinationals, they're saying sometimes like we spend a lot of money in all the software, in all the accommodation, in the infrastructure to make working from home feasible, to facilitate cross-border mobility. So there is a lot of capital spending around that. And then everybody talks about the health crisis, but we also had an ocean freight crisis. There was a boat or a vessel or whatever you call it in English blocking the Suez Canal. And companies were saying, what about my emergency contingency plans? Do I really need one distribution center on a pan-European basis? Do I need more? How much do I need to spend on that? So, and we have a streamlined business model. We have a tax model that is really adapted or really tailored to that. What do I need to do and what is it costing me? So we have the geopolitical tensions, we have the energy shocks, we have prices of commodities going up, going down, going in whatever direction. We have, on the other hand, the technology, as I was already mentioning, that makes value chains, supply chains much shorter, very short if you wish. But on the other hand, there is a decentralization. We have governments, and I don't mean that in an offensive way, but the surveillance by governments and by countries is increasing. So corporates do understand the transparency agenda on the one hand, but surveillance from a governmental perspective, this is something we need to think about. And we also need to think about when we are documenting our business model and how flexible we can be in adapting our tax model to today's strategic realities within companies. So, and then brands. And why do I put brands here on the slide? I was invited about a year ago by the European Parliament. I call it invited. I think it was more like summoned, but I call it invited. And the topic was the future of tax schemes. And I was thinking, that's going to be a nice conversation with the European Parliament, the FIS committee. And I brought in, maybe in a bit of a provocative way, the fact that meaningful transparency is what we need to talk about. Transparency is one thing. We have the directives on administrative cooperation. Every year another comes out. We are now at DAC 8, thinking about DAC 9 or DAC 23, who knows. But it needs to be meaningful. And what I focused on a bit is brands in companies, and I know there are people in the room who know that much better than I do, they are the vehicle of the values of a company. So why would you, pardon my French, mess with your tax matters? Why would you do that? So this whole ESG agenda, who is galvanizing a whole organization. You might think, like Isabel, now you're getting very etheric, but I'm not. This is really very, very important in the way companies think about dealing with their tax matters. So you might think, what does this have to do with this topic of today? Well, the topic of today that I would like to address, and all my previous speakers have already touched on it briefly, we need to have principled rules. And if we have principled rules, we can work with them and we can make sure that we accommodate an increasing mobile workforce. Because where I'm coming from is years ago we had an ECJ case, and I think the European Court of Justice did it on purpose to make people getting in trouble by pronouncing the name of the case. It was on mobility of a person. You remember the case? Hugues de l'Astérie du Saillant. Ask a German to say it. It was just making fun, I think, of things, but it was a very serious precedent, I think. And why do I raise it? Well, I want to go now to the corporate tax aspects for a minute. And I know I'm between you and coffee, so Sveti, make a sign if I'm talking too much. I think you're already doing that, but I'm not sure. Is okay? Good. So the point I try to make on my experiences is, first of all, we do understand what the OECD achieved or wanted to achieve with the BEPS work. So don't get me wrong, Sarah. I'm not gonna be offensive vis-à-vis the OECD. We understand DEMPs. We understand that. We understand that you wanted to attack highly capitalized empty shell companies. We do understand that. But where we do struggle a bit is to understand the control over risk. And I am not as qualified as people like Richard Collier, Andrew Hickman, my colleague Ian Dykes here in the room, to be very, very technical on the topic. But where is the problem? The delineation in the OECD guidelines has to do with where do I have my senior executives? What are they doing? It's important to see whether I can honor a contract. But the risk control framework in the OECD guidelines contains 6 steps, and the 6th step is the pricing. So between step 1 and step 6, there is a lot of work to do. But what we see in practice, that there seems to be a sort of a jump from 1 straight into 6, which means that if I have a geographical proliferation of senior executives, I risk to be in a sort of a default profit split. And as my previous speakers were pointing out very eloquently, and much more eloquently than what I was doing, this is an issue. How to address highly knowledgeable senior executives when they become mobile or when they are working from home. How does that fit in this control over risk framework? And I was on a panel last week organized by the Amsterdam University. And I was on a panel with Richard Collier and also with Manuel de los Santos from the OECD, who appreciated and who said, and I hope I'm not putting words in his mouth that he didn't intend to say, but he said it, we need to think about chapter 1, a refreshment of chapter 1. He didn't use the word refreshment. Richard said you need a complete overhaul. I try to be a bit more neutral on it, but let's look into that control over risk notion, because value creation is something we need to be very serious. And I see a student from Vienna University looking at me like, oh, here she is again about value creation. But what is value creation? And I think academics can say that in a technically robust way. I cannot do that. But what I'm trying to say is value creation is a proxy used for something which is not legally defined. And then we're jumping on these DEMPs. Development, enhancement, management, protection, control. What does it mean? So let's make a shortcut. It's tempting to say, let's make a shortcut. You have important people, and we're going straight into a sort of a profit split discussion without thinking about the delineation. So control over risk in isolation without that being linked to an asset. It's a bit peculiar, isn't it? Isn't it something where it should be linked to how do I win in the market? How do I create barriers to entry? That sort of stuff is very important in the equation. So workforce, well, work from anywhere, hide from anywhere. You can't believe the number of interesting discussions I see when we're interviewing senior executives, when we have discussions at higher senior level. And maybe, Gianmarco, you might think about Netflix series about it, because that's really suspense where the VP HR and the VP tax are getting in a sort of a quarrel. Like, no, I'm hiring wherever I can find the talent, and where the tax people are saying, no, we can't do that. And then we get discussions around the internal governance, so the talent management strategies. Companies are saying, well, people who are transactional, I'm not earmarking them as value creators. That's tough, because It's all about economic rent creation, isn't it? And you may have people in rather routine functions who can be adding a lot of value. You can have the reverse, the opposite. So, and how do you marry these sort of internal governance systems with the tax angle? So, and then there is also the discussion around IP creation. And I was very grateful, David, that you raised workforce in place and a discussion around that. And I think there is a bit of a tension in the way, well, tension, mismatch, difference in view between the US and rest of the world. I can think. But this doesn't take away that, well, where we are saying in Europe, well, workforce in place as such cannot be an asset, but it can have an important repercussion on my transfer pricing stuff, of course. What about ESG people? When you talk to senior management about value creation, there are a lot of companies who are saying, well, because of the importance of my brand, my ESG folks, my sustainability folks are extremely important. You have to explain that to a production manager in a company who is managing a factory. When you tell those people, what do you think about ESG? Ah, go away, go away. If we don't have products, we can't sell anything. So, but what do we do with that sort of cost? There's a lot of cost, ESG, sustainability reports. Does the charging of these costs create IP? And if so, is it linked to the individuals? And where am I going to allocate that to? So I have been dwelling a lot on this slide, but no worries. I can go very quickly over the rest. I won't bother you or bore you with this slide because then you all fall asleep. But this is exactly the reference to the OECD guidelines where there is an opportunity, if I can call it like that, to revisit the guidance in the OECD guidelines. And that is where the delineation is leading to some unclarity, as I was saying, and where also when we talk about intangibles and profit splits and methods, there can be probably erroneously a temptation for tax administrations to jump relatively quickly to anything else than a one-sided transfer pricing method. So risk, that's one thing I wanted to say, risk. If there are several entities that are assuming part of the risk, you have to allocate the risk to the party that is assuming most of the risk. That's not easy. I understand the rationale in the OECD guidelines, what they wanted to achieve, but if you are then trying to apply that in practice, you sometimes get in trouble. And as a transfer pricing person, and let me now become a bit treaty-ish, as an Article 9 person, you get a bit nervous because this is an Article 7 world that you risk to be in, where you are looking at senior decision makings, a purely human interaction, to then assume that the profitability should follow. Because as we know, in Article 7, capital follows risk, risk follows people functions. In Article 9, we start with the contract. This is why the delineation is so important. So, what is it then that we're seeing in practice? Companies are dealing with a geographically dispersed workforce. We know that. And then the question is, where is now my decision making sitting? What we see is more and more above market control. We don't need to have people dealing with everything in each and every country. So what is the transfer pricing question? My previous speakers have already touched on it, and it's easier said than done. What is an HQ actually doing? Is it adding to the sort of value creation so that an HQ should be anything else than a cost plus entity? Should it become a profit split entity? Well, people in organizations, if you would ask somebody, what is my boss worth? I would never say it when he would be present in the room. But, well, it's a challenging question. And then the question is what sort of locations we have the people in. I already touched on this ESG side of thing, but there are other things like the whole consumer data analytics. And I am not going to start talking about that, but consumer data analytics, from where can you do that? Do you really need to be in the location where you have the chief marketing officer and where you have the IP, the trademarks and so on? I don't think so. But what does it mean for my transfer pricing analysis? So I will be now coming to the main point, the main technical point I wanted to make in setting the scene, because it's easy to criticize OECD guidelines and whatever. But what is now the point? We have the delineation. So what are we supposed to do? Look at chapter 1 in the guidelines. We have to do a value chain analysis. Luckily, that was taken out of the guidance on profit splits, thanks to a lot of contributions from commentators when the drafts came out a couple of years ago. So, and I'm talking here about post-BEPS OECD guidance. So we start with the value chain analysis, and then we look at the internal governance, as I was called. What sort of decision-making matrix do I have? How do my KPIs, my profit indicators work? Do I have a RACI model or a RACI model? Do I have a rapid model? What sort of decision-making do I have in my organization? And then I have done my delineation properly. I can go to the transfer pricing analysis. That's what the guidance is saying. So what are we doing now in practice? And it's just one example, Sveti, as I said, I would bring. We are borrowing a concept from macroeconomics, the Herfindahl-Hirschman index. I simply say that to show off that I have been doing some academic research. But no, we're in all seriousness with a couple of colleagues, amongst others, an old colleague of you, Sarah, Georgia Maffini, where we were looking like, what does it mean? Concentration of people, what sort of effect does it have? And why is it relevant? Because if I'm moving person A, who can be a senior executive from company A to company B, can be a VP, can be a very important people in the hierarchy, it is probably less harmful from a transfer pricing integrity perspective than when I move a bunch of people, those people together with their teams. So it is really an index that is used to look at industry concentration, as you probably know. You might think, what does this have to do with transfer pricing? But we are using that to really show the relevance of critical mass. So if companies are dealing with a mobile workforce or with a workforce that works from home, we are looking at what does that mean at the end of the day, at the ultimate concentration of people in certain countries. And the link to concrete assets or comparability elements like synergy benefits that might be relevant for my transfer pricing analysis. I won't go into much detail on that because you would all fall asleep then, but this is this economic significant function deep dive. This is the outcome of what such an exercise would bring. So I take the full-time equivalence by grade with the N is board level, and the 1 is a board level, and then the other ones are somewhat, let's say, lower in the hierarchical grid and lower in terms of value creation per se. But I'm going to look at how are they concentrated? How are they spread over my various countries? Where do I have above market people? Where do I have people who are playing directly on the market dynamics in a particular country? To then see how painful it could be for my transfer pricing integrity if I would make other moves. So that often results in a situation where you might think this is not a situation where we would have a sort of a default profit split. We can still work on a one-sided transfer pricing method. And I don't want to defend that at all cost. But what I do believe is and now I'm going, it's like cursing in a church. I would like to see how to stay away from a tax audit where I would incur the risk of seeing this ending in a so-called profit split, which is actually a formulary allocation. How formulary allocation might morph to some sort of so-called profit split, which isn't a profit split. So we have to go back to a principled approach based on sound transfer pricing principles. And that's why we need, I guess, a refreshment of Chapter 1 of the OECD guidelines. So a few thoughts from my trenches to end. So yeah, what can we do now? Or what are we doing? So first of all, rethinking the master file might be a good idea. And many companies are saying, go away. I don't want to talk about master files. This is compliance. That was so until a while ago. I have various projects where I have the pleasure of being in the teams where master file is reaching board level. We want to make sure that this is understood to stakeholders, including our own personnel. So value creation, let's take that very serious. Whether you apply this economic significant function thing or anything else, just put your business hat on when you are putting together your master file. Solving issues of the past, and this is maybe a small suggestion that I included in that when I heard that there would be a speaker from the European Commission, and I don't want to put you on the spot, you know that, but we have controversy cases, we have MAP, we have some tools, they might work, they might work to a lesser extent. We're not yet there on the one-stop shop. So I think there are a lot of controversy lawyers here who have their lifetime employment guarantee that is not under pressure. But when I look at DAX 7 joint audits, how I read it, and I'm sure there are people much more knowledgeable on that, is that public servants can decide to do a joint audit. But what if taxpayers could also be doing that? Maybe that would be a good idea. Because if I am under pressure on my one-sided transfer pricing method in a country where there is a deemed profit split that has been the allegation made by a tax authority, why can't I say in an EU context, hey, you talk to your counterpart? We tried to raise that in the context of the EU Joint Transfer Pricing Forum a couple of years ago, but I don't think it hit yet the mindset of the legislator, but that might be a nice addition to DAX 7. The bumpy road to meaningful transparency, I don't need to bother you further with that, but there are quite some transparency initiatives out there which I could call less meaningful. Public CBCR doesn't give you an accurate view on value creation and what it means if I have a mobile workforce in terms of my ultimate division of my tax pie in my Willie Sutton Inc. organization. And then finally, testing and supporting the positions. So very much aligning what you do as a company with the tax policy work, with the tax contractual framework and managing risk. Easier said than done for the reasons I said on the start, because strategies, business models are so volatile and the tax function is only following that with a certain time lag. So with this, I hope I respected my time frame more or less, Freddy. Otherwise, well, you can hit my other leg. There's still one to go. So, ladies and gentlemen, thank you so much for having me here. And also everybody at home, you don't know what you miss by not being in Belgrade. Thank you.
Well, we have a few minutes before the coffee break, so I will use the opportunity to abuse the position that I now own the dais, and I will raise a potential question to the inspired by what I've heard. And this is I'll have to do a little bit of an introduction. So, out of what of the pillars, the one that is probably going to survive, and that is pillar two. Pillar one is probably something that is not going to happen. In essence, Pillar 2 would say that you no longer can play with your corporate income tax rate as a tool to attract investment. So we go to this minimum 15% line. But what Isabel said is we focus on key people functions, right? Well, isn't that then an incentive, provided you already have a good infrastructure? And I'm thinking, let's say, Switzerland, uh, to actually start incentivizing key personnel. In that respect, you actually, from a perspective of tax planning, or from tax policy, would enable a jurisdiction to generate far more corporate income tax revenue because now they have to collect it, but because they could, by attracting and relying on the good infrastructure they have plus tax incentives, because where is the idea? Let's assume my country, which is Serbia, introduces significant tax incentives for top management functions. The problem is a lot of people don't know much about the place. They would be wary of coming. Serbian is not a common language. What about the education system? So you would probably go to a more affluent, more well-established jurisdiction, which would have a more of an alluring power for the top management people who, in addition to a tax cut, wish to have a quality of life, which only a few jurisdictions can provide. So if we emphasize key people functions and with the possible mobility of top executives, doesn't actually Pillar 2 then actually additionally favors the already richest jurisdictions on the planet? This incentivizing the poorest one, which cannot compete because they don't have the infrastructure, which is something which you need to provide in addition to the tax incentive to the top executive, if you want that top executive to bring in the family and set up a home. So do you think that I'm being paranoid because I come from a jurisdiction which might be affected, or is there any merit in this scenario? It's up to the dais. Yes, please.
Subsidy financed by the top-up tax. The subsidies go to people earning more than 150,000. That's one idea on the table. But it's a real case that we have to discuss.
Thank you, Peter. So Peter just proved me that I'm not completely paranoid. But Natalia.
The best that could happen to us. This is the best that could happen to us in the UK, because this is an area where we can effectively compete. We have a very good education system. Our health is fantastic. Our infrastructure is perfect. We can now attract the people that we want to attract, and in this we can definitely compete. So this is a perfect world for the UK, and this was explicitly, it's recorded on YouTube. So you're not paranoid.
And what Peter said is actually you fund the incentives by virtue of the additional corporate income tax revenue raised. So if we view this then from the perspective, and this perhaps is something that maybe the UN could take into account, is that if from this perspective there is something on the bargaining table for developing countries to actually demand because it seems that there is a lot for them actually to potentially additionally lose in this respect if it goes through, because they don't have the element of competition, which is the already developed infrastructure. Okay, well, that sums up my question.
I would just, remind you of one of the key messages from the April ECOSOC meeting, which is, I mean, the ATAF, the G24 have been very clear that their concerns have not been taken into account. And what you're describing is just another one of the effects that, I mean, there have been a focus on the incentives and the fact that the incentives the developing countries have used to attract corporate investment will be eaten away by Pillar 2. But I think there are a lot of other effects that developing countries are well aware of and have tried to bring to the table and have not really been heard.
Yarif, please. Natalia, please give the mic to Yarif.
I think it's kind of funny because we're pretending as if we're talking about science here, and especially Pillar 2, as if this is something that all the countries agreed on, and it's a fair system, and we're getting together. But that's not what's happening here. I mean, we live in a horrible world. We live in a world of oppression. In this context, it's not surprising that the ATF considerations don't come into play here, because that's not what it is about. It's about very few individuals, very few countries coming together and creating this pretense of a system where we could kind of cooperating and having a fair allocation of profits. That's not the world we live in. We live in a harsh, competitive world with oppression that we pretend that we live in a civilized society because it's oppression that is not done by empires with ships and guns, but it's kind of equally done. And then we pretend that we have these rules that are based on principles, but that's really not what's happening in this context. And I think that's the source of the problem.
Well, following up on this, it's actually and this is, I think, it will be, it will be to my liking. One thing that this might suggest is that in case of developing countries, actually, the bargaining chips in the negotiations with respect to corporate income taxation could actually be found at the level of personal income taxation, because taking those elements into the equation actually might more better address their interest as well, because this would seem to be a completely one-sided game, especially if you take these things into account. And also, I think that there is another thing. Yari will be talking about this in I think the next session, but I think also another thing which should be taken into the equation, which we've often have forgotten, is the demographic element, and that means basically the struggle for talent, which with the declining birth rates, and if I'm not mistaken, and I'll repeat this, it's I will be citing the new potential Italian Prime Minister Meloni, not my favorite politician, but anyhow, she said we have only 400,000 new Italian born this year in a country of 60 million, which means that it is a demographic cataclysm. If you take the number, it is 10 times less what was in the 1950s, around, well, not 10, but 4 or 5. And in any case, we are having 3 million less children born in the EU than we had in the 60s. So this talent needs to be replaced. And in the hunt for talent, I think we will be even more ruthless in this game than we are, let's say, than we were when we were attracting corporate investment. So I think this also element should be taken into account, because with this, the fight for talent and for the young is definitely something that I think policymakers will be starting to take more and more into the equation. And here I take into account my own country, which for the last 4 years has basically been focusing on introducing measures to stop immigration of the talented by actually stimulating. Please, Dick, can you give the mic to Dick Molinar?
I have a question for Patricia Brown about the approach under the UN model that developing countries want more source taxing rights, want withholding taxes. My question is whether this is really in the interest of the developing countries, because of course it will bring more tax revenue as a direct result. But when this is done in a tax treaty, also the other state has the right to raise a withholding tax. And my idea is that let's say the the money that the residents of the developing countries are earning in the other state might be higher than what residents of the other state are earning in a developing country. And that therefore the tax credit that needs to be allowed by the developing country might be more than what they will get as a tax revenue. So then the balance might be negative. So is the source taxing right, are the withholding taxes really in the interest of the developing countries when those tax credits for residents are taken into account?
It's a good question.
Thank you.
And one of the issues for developing countries is that many of them do not really have they don't have information about the income flows going in one direction or another. So to a certain extent, this is relying on intuition. Um, and one example, because I spent a lot of time thinking about pensions, is, I mentioned that the UN model has alternative B for pensions, which provides for withholding tax. And when you think about it, my guess is that probably that's one income flow that goes from developed countries to developing countries. My guess is with respect to pensions, you might have people from developing countries going to the more developed jurisdictions, working there, and then retiring back to the developing countries. So that would be an excellent example of exactly what you're describing. But I think the question is, and we'll maybe see this play out over the coming years, the assumption, everything that's in the UN model with respect to services assumes that services are being provided in developing countries for developing countries, so that the flows are going in one direction. Now, as I was listening to Sveti saying, well, we have lots of talent in developing countries, how do we use that? And the question is that talent going to move to the developed world? That's the brain drain question, I guess. Or are they going to be able themselves to provide services to multinationals in developed countries? And until we know the answer to that, we really don't know whether those withholding taxes will benefit developing countries or not, for the reasons you've described.
Yeah. That's a clear answer. Well, let me give an example. I'm working in the field of artists and sportsmen, of course, and I would say that this Article 17 is not in the interest of developing countries. For instance, like athletes, marathon runners living in Kenya, Ethiopia, and such. If those countries want them to stay and keep their residents there, it would be better not to have an Article 17 where the US could deduct 30% and the UK 20% and Germany 16%, for which they should give a tax credit back home and perhaps not even levy any tax. So it might be in their favor. It might be an incentive for them to keep their residents in the developing country if there would be no source withholding tax abroad.
I will, okay, because we now have a coffee break, just to confirm what you're saying. The double tax treaty between Serbia and Germany, and that is the biggest jurisdiction for our expatriate population, uses the UN model at the insistence of Germany, because for pensions. Which is interesting, and it was done in the late 80s already, because the assumed repatriation of the pensioners, once they would finish their working age, they would go back to the country of origin. So it's 10:30. The first session ended. Thank you so much to our speakers. It's been wonderful. It's been inspirational for me, at least. Now we have a coffee break, and at 10:45 we resume with our first session. Thank you.